The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain a couple of the different types of guardianship disputes that may occur in a guardianship case. We're going to look both at guardianship cases involving minors and those involving disabled adults. So first, let's look at who may serve as guardian. So if there's no question that guardianship is necessary and the only issue is who is going to actually be the guardian, whether this is for a minor or a disabled adult, the easiest way to resolve this dispute is to have a guardian ad litem appointed to represent either the best interests of the child or the best interests of the disabled adult. A guardian ad litem is basically an attorney that investigates the facts surrounding the case and makes a recommendation to the court as to what the best situation for the potential ward would be. So a guardian ad litem will, if there's multiple people vying to be named guardian, a guardian ad litem will investigate the facts on the ground, interview both of the people, and make a recommendation. Now, the court's not bound by this recommendation, but it will give heavy weight to the recommendation. It's a tough hurdle to clear if you are not the person that the guardian ad litem recommends. Another type of dispute is a dispute over whether guardianship is necessary in the first place. And this is usually the realm of guardianship for disabled adults. This is when the disabled adult does not believe that he or she is disabled and believes he or she can make her own decisions, and that a guardianship isn't necessary. So the way this is resolved is with a trial, and the issue in question is the mental capacity and physical capacity of the disabled adult to make his or her own decisions. And this is kind of a spectrum. It's not a black or white answer. So the disabled adult might be able to make some decisions, but not all, in which case a limited guardianship might be appointed rather than a plenary guardianship, which gives you guardianship over all of the disabled adults' financial decisions or all of the disabled adults' personal decisions. Limited guardianship might say the disabled adult can make some decisions, and those are going to be left with the disabled adult, but these specific types of decisions are going to be cordoned off and made by the guardian. So this is, again, determined through a trial, and at the trial, each side will call a medical expert to testify, doctor, psychologist, as to whether the disabled adult has the mental capacity to make the decisions in question. A guardian ad litem might be appointed to act on behalf of the disabled adult and investigate what the real situation is and make a report to the court. And then each side might call some lay witnesses, friends and family of the disabled adult, that can testify as to their opinion of the disabled adult's decision-making capabilities. So another type of guardianship is guardianship dispute. So far we've talked about disputes over the appointment of a guardian. Once a guardian is appointed, there's a couple other types of disputes that can be involved, and one of those is breach of fiduciary duty. And this is a situation where whoever's named as guardian has a special fiduciary duty to the ward to act in the ward's best interest, not in the best interest of the guardian at the expense of the ward. So the ward or third parties that are interested may have the ward removed and may have the ward pay damages if the ward may have the guardian removed and may have the guardian pay damages if the guardian has breached his or her fiduciary duty. And this can be by negligent or intentional mismanagement of the ward's assets, or by using his or her position as guardian to benefit himself or herself at the expense of the ward or at the expense of other interested parties. So basically, if that happens, if there's mismanagement of the estate, not only will the guardian be removed, but the guardian will have to pay damages for whatever the breach of fiduciary duty caused, whatever injury to the estate or to any third parties or to the ward that the breach of fiduciary duty caused. Another type of guardianship dispute that can happen once a guardianship has been appointed, or a guardian has been appointed, is when a guardian overreaches their powers. So in a plenary guardianship with, basically the full range of powers that the guardian has towards either finances or to major life decisions, even in those situations, there's certain things that a guardian can't do. So a guardian doesn't automatically have the power to decide where the ward is going to live or check the ward into a mental institution without a court order. If the guardian does that and does so wrongfully, that's an overreach of their power, and they can either be removed or their decisions can be undone or they can pay damages. A more likely is when there's a limited guardianship, like we talked about earlier, where they're only allowed to make certain types of decisions, and they start making other decisions that is outside of the scope of the limited guardianship. So, the ward or third parties that are interested can file a lawsuit to either have that guardian removed for overreaching their power or pay damages caused by such overreach. Moving into something that's limited to guardianship for minors is basically a dispute with biological parents to terminate their rights. So a person can't be appointed a guardian of a minor child unless the biological parents have their rights to parenthood terminated first. So in order to petition for guardianship, you need to have standing, and you don't have standing until the parental rights have been terminated. If you file a petition for guardianship without having standing first, the petition will be thrown out of court. So basically, the first issue is whether parental rights have been terminated. And these can be terminated in a couple of ways. It can be terminated by the parents voluntarily giving up custody to the guardian. It can be having them sign a document voluntarily terminating their parental rights. Or if they don't do it voluntarily, there can be a hearing at which the people trying to terminate parental rights have to show that the biological parents, are both unable or unwilling to serve as proper parents and act in the best interests of their children. So it's not something courts like to do, involuntarily terminating parental rights, but if you can show that there's a danger to the children's well-being, then they can do so. And once the parental rights are terminated, a guardian can be appointed. Finally, let's talk about a removal of a guardian based on changed circumstances. So there's kind of three phases we've discussed. We've discussed disputes surrounding appointing a guardian, like who will serve as guardian and whether guardianship is necessary. We've discussed malfeasance, and that's breach of fiduciary duty or overreaching, the scope of the guardianship. We've also discussed terminating parental rights. Now we're talking about removal of a guardian based on changed circumstances, and this can apply to either a guardianship of a minor or of a disabled adult. If it's a guardianship of a minor, it's usually the biological parents showing that the situation has changed and now they are able and willing to serve as parents to the child, and they're trying to get their parental rights back. In the case of a disabled adult, it is usually the disabled adult showing that their condition has changed and they can now make their own decisions and the guardianship is no longer necessary. And the disabled adult can do this through medical expert testimony. So if you have any questions, please leave them in the comment section below this post at learn-about-law.com or below the YouTube video on our YouTube station. It's a big help to us if you subscribe to us on YouTube, iTunes, and SoundCloud. If you found this helpful, we'd really appreciate it if you do that. If you need our help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. Thank you so much for listening and watching.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.